Hello and welcome to the program. I'm Shola Shoyeli. The frequency with which conflicting court orders are issued, especially on political cases, continues to agitate many. What is responsible for this and why does the trend persist? In this interview, Senior Advocate of Nigeria, Dele Adesina, proffers some suggestions.
First, let me say that there is no problem without a solution. Just as there can never be a question without an answer. But having said that, the problem has persisted because we have not found the right solution, if we have found any solution at all. Talking about a problem, yes, it's okay, but talk only will not solve it. There has to be functional talk. There has to be practical steps taken to identify offenders and sanction them appropriately. Without punishment, people will continue to commit offenses. It is the fear of sanctions that make people to desist from committing offenses.
One of the ways that the CJN tried to deal with this issue was to invite the chief judges of states where we had some of these conflicting court orders.
Yes.
And talk to them. And after all of these meetings, we even heard that queries were issued to some judges. Now, the bar on its part also drew attention to it, like you said, and I think they set up a committee. But we've not heard anything after that. Would you agree with those who say that the bar, past administrations of the bar, perhaps the current administration, the leadership of the bar, seems to shy away from identifying and dealing squarely with the lawyers involved who filed these cases before the different judges?
Well, your question is frontal, and you know me, okay? I will not avoid answering your question. And I hope people will look at your question and the answers I'm going to give you objectively. For those who think like you have narrated, I don't think they are wrong. I do not think they are wrong. Are you with me? You say, a serious problem requires a serious solution, pragmatic and realistic solution. Now, yes, it is true the CJN invited some judges, we knew the time. He probably did all that as the Chief Justice of Nigeria, as the head of the judiciary. But when it comes to real sanction, it is the business of the National Judicial Council, right? That is there, as far as the judges are concerned. And at least Nigerians could see that some things were being done along that line. But with regards to the bar, we have the Legal Practitioners Disciplinary Committee. Nigerians must stop being passive, right? Let them take practical steps and write petitions, write letters to the leadership of the bar to say this is what Mr. So-so-so and so did, this is what Chief so-so and so did, which we think is offensive to our sensibilities, offensive to the practice of law. I'm sure the leadership will not close their eyes to such a petition. I know that we used to have, apart from the Central Legal Practitioners Disciplinary Committee, we used to have clearing houses, of disciplinary committees at different branches, to look at petitions. And any petition where they find out that there is a prima facie case against the person petitioned against, they will refer it to the LPDC without missing words. Unfortunately, that is the system, right? If the system says there has to be a petition, there has to be a petition. If there is no petition, the person will go scot-free.
But isn't it time to do away with that practice of waiting for petition?
That is where I'm going when I said but. But it is high time we begin to shift. There has to be a mechanism, of getting these things done. For example, if a lawyer appears before a court and the judge or judges or justices, if it is an appellate court, feels that the lawyer has gone beyond the realm permitted by the ethical standard of the profession, without anybody writing petition, the court should be able to refer such a lawyer to the Legal Practitioners Disciplinary Committee. I haven't seen it done, but nothing should stop it from being done. That is when we can become more accountable. It's a profession that pays high premium on ethics, on professional ethics. The code of conduct of the profession is very strict, and it's written in black and white. There is no, is it not?
Because with all of
But
these
our
cases,
enforcement mechanism has to improve
yes,
to get the desired result. I can assure you, immediately 2 or 3 lawyers are sanctioned. These things will be no more.
yes, because with all of these cases of conflicting court orders that we hear, it was some lawyers who filed those cases, and they are known to members of the legal profession. And I'm not aware, I have not read, I have not heard that these lawyers are facing any proceedings
I've told
to
you
explain.
the reason why. Now, if I'm in this office and somebody brings a matter to me and he wants me to handle it, at our level here, we take decisions. We don't just take any case that walks to our office. I've had cause to reject a Supreme Court case here because I felt I felt it was not a case to be brought to the Supreme Court again. And I told the client, sorry, I have to give this personal experience, but you need to emphasize some of the things we are saying through this kind of illustrations. The client brought the matter here, and I told him, you have a very good case, but the time to ventilate your grievances is spent. It was an election matter. He went to the Court of Appeal and lost. The Court of Appeal gave a judgment and said they would deliver their reasons later. And there was an appeal to the Supreme Court. By the time the Court of Appeal delivered that ruling, it was outside the 60 days permitted by the Constitution. Right? So he came here and he was of the opinion, by the time his appeal was decided by the Supreme Court, both judgments were thrown out, both the judgment and the reasons given thereafter. They said the Court of Appeal cannot give a judgment without advancing reasons. Not being the final court of the land, they also cannot give such reasons after the expiration of the 60 days. So the judgment of the Court of Appeal was declared a nullity. Right? So the client thought that if the Supreme Court had declared the judgment a nullity, they should have assumed the position under the Supreme Court Act and then decide that matter on the merits. I said, you are right. He has personally done all the homework on the consequences of an act being a nullity. I said, you are correct. It's as if that judgment did not take place. But that is how far you can go. The law also says that the Supreme Court must start and finish this matter within 60 days. They have done that. For you to now want to go back 3 months after the judgment, you are already out of the time. And we rejected the brief. It went to another senior advocate who accepted and took the matter to the Supreme Court. Of course, the matter was thrown out through the window. You get my point? So we have to put energy into the enforcement of our law. Any law that is not enforced is useless in the statute book.
So just like you talked about your law firm doing its checks and internally before accepting a brief, there's also this question that agitates my mind about the judges. I mean, we've said so much about this issue of conflicting court orders. Can the judges who some of these cases come before, can they genuinely claim not to know that there have been similar suits on such cases that are coming to them? Or even when a case is assigned to them, can they go back to do their own checks to find out if if similar suits have been filed on such an issue before sitting on it. I mean, with all that we've said about it, shouldn't the judges also do their own checks
You see,
individually?
I've done a lot of work about the state of our judiciary and the need for a better administration of justice in this country. Having regards to the situation under which most of the judges operate today, I doubt if they can have time to do that.
Isn't it
And
just,
let
isn't
me
it
laugh.
just
You
as
see,
simple as passing it off to their research assistants or the people who work with them, check if there are similar cases on this? They don't have to do
do you
it
know how many
personally.
cases are filed per day in this country? In Lagos State alone, this is October, the cases that have been filed this year, I'm sure, are in excess of 5,000. Most of these judges will have about 20 cases in one day. At the Court of Appeal on Monday, there were 18 cases. I was before that court on Monday. 18 cases. On Friday last week, there were about 9 cases before the Supreme Court. So the problem of the judiciary is both systemic, it's structural, and it's attitudinal. And until we address these problems, it will continue to be what it is.
I hear what you say, but I think we can agree that most of these cases where we have these conflicting court orders are political cases.
I will come to that.
And they are ex parte, the lawyers usually come ex parte. So with that, when the lawyers come ex parte, is it not just as simple as picking a phone call to confirm, maybe from the registry, if there are no cases like this before? I don't know. I think that there should be something in place that a judge can use to cross-check.
I don't think we have that data, functional data, where somebody can press his system, a judge can press his system and know all the cases that have been filed in Lagos. Are you with me? And immediately know the facts of the cases.
Even the admin judge who assigns the cases will not know.
How many cases does he assign in a day? We need to move away from this analog to technology.
Sure.
And once we do that, it's just a matter of pressing your buttons. I remember by the time we proposed judicial, you mentioned it, research assistants, many years ago, some of the judges even rose against it.
Why?
They gave a reason. They said that their judgments will be leaking. Whatever system you are bringing, people have to look at the environment. The MBA at the time had to persuade the leadership to say, no, we are not asking that the judicial research officers will be writing judgments, no. But they can assist your lordship in looking for authorities that you are going to apply without the research assistant knowing whether you are going to decide one way or the other. Today it has become a system. So there's a limit to which we can blame our judges. They are operating under a very severe condition. But I think the bane of our problem, if we can summarize it, is one, there is no effective sanction for infractions. We need to step up, not only at the level of the profession, but also, when I say the profession, I mean both at the bar and the bench. And more importantly, the politicians, the clients too, must be answerable. The do-or-die affair which characterizes our politics in Nigeria has to stop. That is what is giving rise to that. If you want to contest an election, you participate in the primary and you didn't win, go to your home. But here in Nigeria, we want to be the candidate at all costs, even if heaven will fall. That is no rule of law. That is not democracy. So there has to be that willingness to abide by the rules and stop a do-or-die politics.